Hey guys, Dark Angel here. Hey, as if Cameron James Wilson wasn't enough for you, where you already proved that it is perfectly legal to drive, travel, without a license, registration, and plates, I mean, his case said a lot, and he's got another one coming up, as I mentioned before. So now, today, what I'm going to do is I'm going to go ahead and show you why. This one's going to be called a title of nobility. For those of you that don't know what a title of nobility is, okay, so we're going to go into that and show you the difference. We're going to show you why a title of nobility and a driver's license are so compatible. As a matter of fact, they are very compatible. So, with that said, I'm going to go ahead and get right into it because I'm not going to try to make this a long video because this is going to get straight to the point and maybe add a little bit more oomph to whatever it is you traders, bootlickers, and haters think, okay? So, in a title of nobility, the Constitution for the United States of America, Article 1, Section 10, Clause 1, prohibits the granting of a title of nobility. No state shall grant title of nobility. Since the granting of a title of nobility is absolutely prohibited, this court lacks subject matter jurisdiction to enforce a title of nobility and its attendant rules and regulations. That means any court who tries to persecute or execute a case under a title of nobility is without jurisdiction. So, Utah Supreme Court has stated that ability to drive a motor vehicle on a public roadway is not a fundamental right, but a revocable privilege. City of Salina versus Wisdom, 733. The distinctive appellation and designation or title driver is a title of privilege, a title of noble privilege, a title of nobility. Now, I think we haven't even got into what the definition of nobility means yet. So, hang on, because it's getting there. In the words of Thomas L. Wilmore, city attorney for the city of Trenmonton, Utah, case number 940336, a title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and Phrases, Volume 8A, page 40. A driver's license is a privilege which is granted by the state, a municipal corporation. In other words, to obtain a driver's license is to be nominated to an order of persons known as drivers and be granted the special privileges that attach to the title. The United States Constitution at Article 1, Section 10 prohibits the states from granting a title of nobility. A driver's license and its attendant rules and regulations. Pursuant to the City of Salina versus Wisdom, the driver's license and its attendant rules and regulations are by definition a title of nobility. Article 1, Section 10 of the United States Constitution prohibits the states from granting a title of nobility. The court lacks subject matter jurisdiction to enforce upon the defendant title of nobility. What is prohibited to the states is forbidden to the court to enforce. California Motor Transit Company versus Trucking Unlimited, 404 U.S. 908, 1972. So that goes to show you, if the courts, if a state is prohibited from being able to enforce something. A court lacks jurisdiction in that subject matter because the state has no authority. So there's that. What is prohibited to the United States is forbidden to the court to enforce. Therefore, the accused requests the court to make a legal determination as to what is a title of nobility. The following case law will define a title of nobility for the court to use to make its determination. The following quotes give you the answers. Nobility: an order of man in several countries to whom special privileges are granted at the expense of the rest of the people. Bulwer's Law Dictionary, 1870. To confer a title of nobility is to nominate to an order of persons to whom privileges are granted at the expense of the rest of the people. It is not necessarily hereditary, and the objection to it arises more from the privileges supposed to be attached than to the otherwise empty title or order. Horst versus Moses, 1872. Let's see. Corpus Juris 598, Nobility, Note 4, 1874. Bulwer's Law Dictionary, Nobility. These component terms privilege, honor, and emolument are collectively in the term title of nobility. Horst versus Moses, 1872, 48, Atlanta. So there you go. The government granted entitlement privileges such as a driver's license, and its privileges are obviously noble entitlements and franchises, as pointed out by Richard B. Stewart, left-wing politician, Rhodes Scholar, and Harvard Law professor. The third great innovation in American administrative law, which has largely occurred during the past 20 years, extended the procedural controls and principles of judicial review developed in the context of regulatory decision-making to the operations of the welfare state, including programs of government insurances and assistance, government employment decisions, and the administration of government grants and contracts. Under traditional private law principles, these benefits were privileges and not rights, because their withholding did not constitute the commission of a tort or other natural law, wrong against a disappointed applicant or terminated recipient. With the growth of the post-World War II warfare state, the distinction between rights and privileges gradually eroded. Statutes conveying these various benefits and advantages were held by courts to create entitlements. The limits of administrative law in the court's separation of powers final report on the 1983 Chief Justice Earl Warren Conference on Advocacy, page 77, Library of Congress. The Constitution for the United States of America at Article 1, Section 10, Clause 1 mandates, no state shall grant any title of nobility, and the establishment of the prohibition of titles of nobility are perhaps greater securities to liberty and republicanism than any the national Constitution contains. Nothing need be said to illustrate the importance of the prohibition of titles of nobility. This may be truly denominated the cornerstone of Republican government. For so long as they are excluded, there can never be serious danger that the government will be any other than that of the people. Danger: nobility government, that of the police state. The Federalist Papers, 484, S and 6, Alexander Hamilton. A title of nobility is privilege of license and license of privilege. Otherwise, such title of nobility ceases to exist without such privilege of license and license of privilege. A license to drive is a title of nobility in that it is a special grant privilege to use vehicles upon the public highways and roads. So says the Utah Supreme Court, cited in Salina versus Wisden, Supra. The state of any state, Oregon, Washington, whatever state, acts as a king who grants titles of nobility when it takes away a natural existing public or private right, forbidding a natural activity or occupation to all, then turns around and specially grants it back to a few or many, the special privilege to engage in that activity or occupation, and requiring the obtaining of a title of noble privilege, driver's license, license plate, to drive vehicles and obey and attending nobility rules as applied to the accused, is contrary to the Constitution for the United States of America mandate at Article 1, Section 10, Clause 1. No state shall grant any title of nobility. Hence, again, put your state in there. All attendant nobility traffic rules, regulations, and penalties made pursuant to such is to the contrary of the res judicata mandate of the Constitution for the United States of America, lest we be corporate slaves. And it is notwithstanding and void by mere operation of law upon this record, as applied to the accused. Hence the court lacks subject matter jurisdiction because of the prohibition of titles of nobility, attendant rules, regulations, and penalties. So there you have it. That's just to sum it all up in just a nice, neat little nutshell, and put it point blank and simple. Bottom line is a license is a title of nobility. It actually 100% matches the definition of what a title of nobility is. It's not so much as the title, it's the privilege that the title allows. That's what the title of nobility is. So for those of you that didn't know that, now you know. Now you're in the know. And I want to thank Cameron James for that, because that was actually something that he brought to my attention through some paperwork of his. And I was aware of it, but I never gave it any thought as to the actual power or extent of how it could be utilized until I saw the explanation that he expressed in his paperwork. And then after I gave it a little thought and researched it, I realized that he is absolutely 100% correct, that in granting of a title of nobility and only being given certain privileges that certain people can have and certain people cannot have, it's a perfect match. But anyway, like I said, this was just going to be a little short video just to give you guys a head up as to titles of nobilities and driver's license, as to what they actually are and how they are compared with each other. Okay, so with that being said, I hope you guys enjoyed that video of Cameron James Wilson and his win, proving that traveling without a license and registration and plates is legal. And I hope that you guys can get this information in there too, and get it in your head and realize that, well, look up the term title of nobility, look up the definition, and then look at a driver's license, and then you'll see they're both prohibited. Okay, they're both prohibited, and you can't prohibit the one without the other one unless the legislation went up and changed the Constitution, and they did not, because still in the Constitution it still states that at Article 1, Section 10, Paragraph 1 about title of nobility. So that is still the Constitution to this day. It is what it is. It's the law. So wake up, wake up. This is Dark Angel. Deuces.